This is Barry Zalma, Zalma's insurance fraud letter for January 1, 2022. This will be the first issue of the 26th year of Zalma's insurance fraud letter. One of the articles in the fraud letter is an article about why State Farm and Allstate are fighting fraudsters with qui tam suits, because it is now essential that insurers are proactive against insurance fraud. Insurance companies are the victims of billions of dollars every year from insurance fraudsters. They have found that states and police agencies are either unable or unwilling to prosecute those who defraud insurers. In the People ex rel State Farm Mutual Auto Insurance Company versus Sonny Rubin, a California Court of Appeal decision rendered on December 14, 2021, State Farm took proactive steps by filing qui tam suits based on the California Insurance Frauds Protection Act, the IFPA, that allows qui tam plaintiffs to file lawsuits on the government's behalf and seek monetary penalties against perpetrators of insurance fraud. The introduction of the State Farm complaint describes the alleged scheme. It stated that Dr. Rubin's routinely recommended, predetermined, one-size-fits-all treatment plans without regard to medical necessity or patient safety to fraudulently increase the value of plaintiffs' claims and to maximize his own revenue, profit, and income. In furtherance of this scheme, defendants prepared bills for treatment and procedures represented to have been rendered by Dr. Rubin, which contained false statements about the nature of services allegedly provided, the cost of such services, and the location of where services were provided. The introduction then explained, in part, how the scheme was accomplished through the manipulation of billing codes to maximize reimbursement. Bills submitted by the defendants grossly inflated the value of the services rendered and often contained charges for treatment that was never provided, or multiple charges for the same treatment. Under the IFPA, a defrauder is assessed penalties for each fraudulent insurance claim it presented to insurers. To protect against duplicative lawsuits, the IFPA contains a first-to-file rule that bars parties from filing subsequent actions related to an allegedly or already pending lawsuit. State Farm Mutual Automobile Insurance Company filed an IFPA action alleging defendants Sonny Rubin, M.D., Sonny Rubin, M.D., Inc., and Newport Institute of Minimally Invasive Surgery, collectively referred to in the article as defendants, fraudulently billed insurers for various services performed in connection with an epidural steroid injection. A month prior, however, another insurer, Allstate, filed a separate IFPA lawsuit against the same defendants, alleging they were perpetrating a fraud on Allstate, also involving epidural steroid injections. The trial court sustained the defendants' demur to State Farm's complaint under the IFPA's first-to-file rule, finding it alleges the same fraud as Allstate's complaint. State Farm appealed, arguing its complaint alleges a distinct fraud. In applying the rule, the court and both parties only focused on whether the two complaints alleged the same fraudulent scheme. But in this matter of first impression to the California Court of Appeal, The Court of Appeal found that the IFPA's first-to-file rule requires an additional inquiry. Courts must also review the specific insurer victims underlying each complaint's request for penalties. If each complaint seeks penalties for false insurance claims relating to different groups of insurer victims, the first-to-file rule does not apply. A subsequent complaint is only barred under the first-to-file rule if the prior complaint alleges the same fraud and seeks penalties arising from the same false claims submitted to the same insurer victims. Here, both complaints largely seek penalties relating to separate pools of victims. Allstate's complaint only seeks IFPA penalties for the false insurance claims that defendants presented to Allstate. State Farm's broader action seeks penalties for all the false insurance claims that the defendants submitted to any insurer. Allstate is the only overlapping victim. Thus, even if the two complaints allege the same fraud, State Farm is only precluded from pursuing IFPA penalties for the false claims that defendants billed to Allstate. As to the other inquiry, there is partial overlap between the fraudulent schemes alleged in the complaints. Both complaints allege a common scheme in which defendants presented false claims to insurers pertaining to epidural steroid injections. However, State Farm's complaint also alleges a distinct scheme involving false charges for magnetic resonance imaging, or MRI, interpretations that defendants billed independently from epidural spinal injections. Based on these findings, as to the portion of State Farm's IFPA action relating to epidural steroid injections, the first-to-file rule only bars State Farm from pursuing penalties for the false claims that defendants allegedly submitted to Allstate. It may still pursue penalties for any false claims that defendants submitted to other insurers. For the portion of State Farm's action based on MRI charges billed independently from epidural spinal injections, State Farm may pursue penalties for any false claims that defendants submitted to any insurer, including Allstate. Now, how did this all come about? The IFPA, which is Insurance Code Sections 1871 et seq., was enacted in 1993 to combat workers' compensation fraud. It was extended to insurance fraud through a 1994 amendment. To assist in the fight against insurance fraud, the IFPA contains a qui tam provision empowering interested persons to file lawsuits on behalf of the government against perpetrators of insurance fraud. Even back in 1994, the legislature of the state of California recognized that the state was doing a fairly poor job of investigating and prosecuting insurance fraud, and they enacted this section to give the victims a weapon to help the state do what it was required to do to protect victims of insurance fraud. The person who brings the qui tam action, called the relator, stands in the shoes of the people of the state of California, who are deemed to be the real party in interest. The relator in a qui tam action under Section 1871.7 does not personally recover damages, but if successful, receives a substantial percentage of the recovery as a bounty. Penalties are assessed for each fraudulent claim presented by a defendant to a victim insurer. A qui tam relator is essentially a self-appointed private attorney general, and his recovery is analogous to a lawyer's contingent fee. The relator has no personal stake in the damages sought, all of which by definition were suffered by the government. This enforcement mechanism is intended to provide incentives for individual citizens to come forward with information uniquely in their possession, and to thus aid the government in ferreting out fraud. The bounty advances the public purpose and benefit by encouraging private qui tam actions. Indeed, this prospect of reward may be the only means of inducing such private parties to come forward with their information. The statute contains a public disclosure rule that precludes parasitic or opportunistic actions by persons simply taking advantage of public information without contributing to or assisting in the exposure of the fraud. The provision at issue in this case, Section 1871.7, Subdivision E, parentheses 5, is generally known as the first-to-file rule. As explained below, other state and federal statutory schemes contain similar first-to-file rules. The IFPA's first-to-file rule provides, when a person or governmental agency brings an action under this section, no person other than the district attorney or commissioner may intervene or bring a related action based on the facts underlying the pending action, unless that action is authorized by another state statute or common law. This action, the one State Farm filed against Dr. Rubin, includes the facts that on October 23, State Farm filed the action against the defendants, which are composed of Sonny Rubin, M.D., and other entities. Dr. Rubin specializes in pain management procedures, including patients experiencing neck and back pain. State Farm alleged Dr. Rubin fraudulently billed for various services performed in connection with epidural steroid injections, a form of pain management, and these services included fluoroscopy and many other medical services. The article goes on in great detail explaining what Dr. Rubin did and why it was fraudulent and different from the information alleged by Allstate. In summary, as to the portion of State Farm's IFPA action relating to fluoroscopy, epiduralography, myelography, evaluation of management services, and the MIR charges billed in connection with epidural spinal injections, State Farm may pursue penalties for the false claims that defendants presented to any insurer except Allstate. And as to the remaining MRI charges, State Farm may pursue penalties for those charges the defendants billed to any insurer, including Allstate, that were not billed in connection with an epidural spinal injection. And in so doing, the Court of Appeal reversed the trial court. This issue of Zalma's insurance fraud letter also includes an article about a case called Steve Ellis Carrasco versus David Shaver, which proved that some insurance fraud perpetrators are simply annoying and need to be put down. An article about an insurance company's summary judgment being granted in Sean Parsons versus Liberty Insurance Company, a United States District Court of the Northern District of Texas article. An article about my free insurance videos. an article about another annoying insurance criminal whose motion for early release from prison after his conviction failed in a case called the United States versus Irina Vorontinov, a U.S. District Court of Minnesota decision. In addition, good news from the Coalition Against Insurance Fraud provides information about a new law in Florida requiring adjusting companies to register with the state and various convictions for insurance fraud. A listing of health insurance fraud convictions, starting with a conviction of Dr. Howard Wallace Oliver, a medical director of a Long Beach addiction center, who was convicted of multiple cases of insurance fraud, along with many other convictions, with the U.S. Attorney apparently getting very aggressive at the end of the year against health insurance fraud perpetrators. A listing of other than health insurance fraud convictions, starting with a story about a former adjuster who was sentenced to 3 years in prison for Kentucky crop insurance fraud that involved over $2.2 million in fraud. In addition, other convictions are reported in detail, as are stories about new insurance books for the insurance claims professional, a listing of blog postings from Zalma on insurance, information about a new series of video presentations and text on insurance claims called Excellence in Claims Handling, where for a subscription to locals.com, Zalma on Insurance, you can view these videos and other postings. The newsletter is available, of course, free on my website, Zalma on Insurance, by going to www.zalma.com and clicking on the link to the Zalma's Insurance Fraud Letter. If you found this video to be useful to you, please pass it on. It's free, and your colleagues may find it useful or interesting. And please also subscribe to Zalma's Insurance Fraud Letter, to my blog, to my Substack publications, and to my Locals community, so that you can be made aware of future videos and of future long-form videos and publications that will help you become an insurance claims professional. Thank you for your attention.